everybody. We're going to get started, I think. We had a couple various timing of our breakout rooms, so. All right. Whenever you're ready, David.
Okay. We're here to talk about the Supreme Court and religion. For a lot of years, a lot of decades, 1970s on to about 2010. At this conference and almost every year there was a big religion case, and almost always they grew out of the concern that the government was promoting or putting its thumb on the scale of on the side of official religion or religion in violation of the Establishment Clause. There were cases about crosses or the 10 Commandments on public property, or the cleric who was invited to give the graduation prayer at school, or state or federal funds that were going to religious schools, or computers for religious schools. And one of my favorites, I think, about the high point of that era, the court struck down a voluntary, a silent meditation law on the grounds that it could encourage voluntary prayer in schools. The last 10 years, the Roberts Court, the concern has come from the opposite direction, that the government is restricting or infringing the free exercise of religion. The court feels very strongly about that, takes up one case after another. I thought it was interesting, a couple months ago, Justice Gorsuch wrote a long concurrence that basically argued that the overly broad interpretation of the Establishment Clause in the 70s and 80s has led to all the religious liberty cases now. The Bremerton school officials thought they couldn't allow the coach to do the prayers on the 50-yard line because doing so would be an Establishment Clause violation. That's what they said, and they won on that. The city of Boston allowed everyone, every group that came forward, dozens of them, to fly their flag for a day. But a Christian group came forward and had a cross on the flag, and they said, no, we can't do that. It would violate the Establishment Clause. And the state of Maine gave scholarships to kids who didn't have a high school in their own small town. They could go anywhere to high school, any private school out of state, but the state said, no religious schools, it would violate the Establishment Clause. And as I think you know, in the last term, the court took up all three of those and reversed 6-3, 6-3, 9-0. So that's sort of where we are now, that religious liberty is on the rise, the Establishment Clause is in retreat. We've got one good case to talk about, not a very good name, 303 Creative, which doesn't tell you much, but it's a good case about religion and free speech. We have an excellent panel of experienced advocates before the court. Willy J. from Goodwin Proctor, Erin Murphy, who's practiced for a lot of years with Paul Clement and has a firm with a good name of Clement Murphy. Paul Smith at the Campaign Finance Center now, and Andy Pincus with Mayor Brown. And we're going to let Paul start to talk about 303 Creative.
So 303 Creative is, I'm sure some of you know, as most of you maybe, is a follow-on from Masterpiece Cake Shop brought by the same lawyers. It raises the question of whether that same Colorado public accommodation law that bans discrimination by a business against customers based on their sexual orientation can constitutionally be applied to a would-be website creator, wedding website creator, 303 Creative, which doesn't want to provide wedding website services to same-sex couples that are getting married. You recall in Masterpiece Cake Shop, that was the cake baker in Colorado who didn't want to provide cakes to celebrate the weddings of same-sex couples, and he brought both free exercise and free speech claims against the application to him of the anti-discrimination law that regulates public accommodation businesses like a cake shop in Colorado. The court in that case didn't end up actually merit either free exercise or free speech claims. Instead, found a way to conduct the case by finding some animus against religion in the record of the Colorado Civil Rights Commission's proceedings, and using that as a way to say that there's a sort of an as-applied free exercise challenge violation. They didn't really decide anything there. The new case is brought by this company that's a graphic design firm. It doesn't actually have any business of making wedding websites yet, but the owner says that she wants to get into that business. And the first thing she would like to do in announcing that new part of her business is to put a notice on her company website that says we're providing these services, but only to non-same-sex couples. So same-sex couples need not apply. You might argue whether this is a real case or controversy, since there is actually no business that's at issue yet. But I think, in the end, the court seems to not be worried about that. Maybe the desire to post the notice on the website, which would itself be a violation of the public accommodation law, may very well be what's getting them over the Article 3 problem, because it's an immediate regulation of her would-be speech that she would otherwise be doing right now. As in Masterpiece, there's both free speech and free exercise claims that were brought by the lawyers. Both of those were rejected in the courts below, the District Court of the 10th Circuit. The Supreme Court granted review, but didn't grant review of the free exercise issue. So they're not getting any religion issues into this case at all. Nothing about the issue of whether the Smith versus Employment Division case needs to be abrogated, any of that stuff that we heard about in the Fulton case a year ago. It's all going to be a pure free speech case, and the court came up with its own not entirely balanced question presented, which was whether applying public accommodation law to compel an artist to speak or stay silent violates the free speech clause of the First Amendment. So that's the question that's going to be decided. Effectively what the issue in the case is, can a state says as a price of getting into the business of an expressive business like creating websites, can the price of that be that you have to provide speech that you don't want to provide to customers whose weddings you think are immoral under your religious perspective? You'd have to say, given the way they phrased the question presented, the court seems to be heading in the direction of deciding that this application of public accommodation law does violate the First Amendment on these facts. It's an as-applied thing. The website designer lawyers do have some cases they could cite where public accommodation laws have in the past been held to violate the First Amendment. There's the Hurley case involving the St. Patrick's Day parade in Boston, where the gay Irish group was not allowed to march. And they were sued. The court said the parade had a First Amendment right to reject them. There's the Boy Scouts case, the Dale case involving a similar situation. Both of those, of course, were non-profit expressive groups claiming a right of association. This is a pure for-profit business, and you might have thought that makes a difference. Apparently, to this court, it doesn't. And the state is basically saying, all we're really doing is regulating sale of goods and services to the public. We're not telling you what you have to think. We're not telling you what you can say. You can say whatever you want about the marriage rights of same-sex couples. You just can't deny them the services that you're offering to the public in your business. The state's also going to be arguing that whatever message of support for same-sex weddings is implied from the websites that it would have to create if it complied with the law wouldn't really be attributed to the company anyway. I think that the website is the website of the marrying couple, not of the business. As in Masterpiece Cake Shop, a big part of this case will be how to limit the theories and whether there can be limits, or whether the court would be really creating a slippery slope problem if they buy this First Amendment claim. If the court holds that there's a First Amendment right to turn people away when you're a wedding website designer, the question will be, who else gets to have that same right? All the other vendors to weddings, or although the lawyers have started these cases all up with wedding vendors, why should it be limited to them? Why wouldn't it be anybody who doesn't approve of a particular relationship, lawyers advising a same-sex couple about their legal arrangements, or doctors who don't want to treat a lesbian couple for gynecological services? I mean, why wouldn't all of this be equally covered? And for that matter, why is it limited to people who disapprove of LGBT people? Why wouldn't it also apply to people who disapprove on religious grounds against women in the workplace, against blacks and whites working together? All of these things would be very difficult lines to draw if the court takes the step in this direction, as it seems like it's going to do. On the other hand, the plaintiffs have a line drawing arguments of their own and say, if you really reject this claim, you're going to be buying a lot of stuff that's hard to accept as well. I'll just read you a couple sentences from their brief. Under Colorado's theory, officials may compel commissioned speakers to speak any message at all, from forcing Democrats, artists to design posters promoting Republican events, to compelling environmentalist designers to create billboards denying climate change, requiring Hindu calligraphers to write flyers proclaiming Jesus is Lord, or enlisting ad designers who celebrate body positivity to create a campaign for a weight loss program. So the question ultimately is, what are the limits of the ability of a state to use its public accommodation laws to force expression that a business does not want to engage in because it disapproves of the message? And so it is a thorny issue. It would appear that we're going to be talking about the first set of line drawing problems, not the second set of line drawing problems when we come back here in a year, because I think that the way the question presented was asked and the court we have now, you'd have to assume that the wedding website is going to win. But that would be just my view. I'm interested in others.
Erin?
I mean, I will certainly, I very much agree with the last thing you said. I think the court, I think if you go back to Masterpiece and generally to the line of cases that have been teeing up this issue, I think a majority of this court does not think that the question of whether you should, the government could compel the speech is hard if you're talking about somebody whose business is expression. I think most of this court thinks, if you're in the business of expression, we don't get to dictate what expression you do. That's basic compelled speech, and we kind of reserve compelled speech for areas where we're doing things like making sure you're not engaging in fraudulent speech and stuff like that. So I think the court thinks that question's not hard, but what they found in Masterpiece is the really hard question is, how do you decide what's speech? And I think they picked this case. There's been plenty of cases out there that have teed up these issues. There've been plenty of them that, and in this case, they tried to tee it up. Really, the only thing the court kind of changed in their framing of the question presented is to take out free exercise, but they've been trying to tee this up as both a free speech and a free exercise issue, and the court wants to take it clearly as a free speech case, and they wanted to take a case where I think in their mind they viewed this as, this one's pretty clearly speech, because we're talking about somebody who is providing not just a service, but who does custom websites, and you're hiring this person because of what they do to help you put out a message, and they're engaged. I think the court thinks, in this case at least, that this court thinks that part is not hard, and let's make the law on the First Amendment and then save for another day all those tough questions about exactly where you draw the line on speech. But I will say, I think that one of the things that the petitioners here have to say that is quite true is it's not like there's no other, it's not like if you don't have to draw that line here, there's no context in the rest of law where you have to draw that line. There are plenty of areas you have to decide for lots of First Amendment purposes what is and isn't speech. And yeah, there are going to be tough issues and tough questions, but I suspect the court's hope is that by taking this issue up in this case, they can say a little bit less about that in their opinion than.
One quick comment though, it seems until these cases started coming along, the line I think most people assumed was between the whole private realm where you get to make choices about who you associate with and what you say and don't say, and the business realm where once you decide to open a business serving the general public, providing a good or a service, you decide to take on the obligations of complying with the basic core anti-discrimination laws. And therefore, that would be a clean line, which now it looks like it's going to be breached. And I think it's a difficult place to stop once you breach that line.
I don't think that's really, I mean, historically, there just isn't really some historical tradition of applying accommodation laws in the context of people whose business is speech. To the contrary, if you look at things like regulation in the context of the press and things like that, that's where the court has always said, like, actually, no, we're not going to compel. If what your product or service is speech, we view that quite differently. And so, yes, absolutely, as an accommodations law, you can say, and 3 other creative here agrees, like, you can't turn someone away because of their sexuality. If a same-sex couple says, hey, we want to pay for the website for our opposite sex friends who are getting married, of course you can't turn them away, because that would be discriminating on the basis of who's asking you for the service. But the objection here is to the message and the speech. And I do think it's actually, a real step in a different direction to say that you can apply accommodations law in the context of people who are engaged in the business of First Amendment protected activity.
Erin said most of the things I wanted to say. The one thing I would just elaborate on is Paul's point about to what extent does it matter if the public sees the speech as the businesses as opposed to the clients? And I do think that is a little bit harder in this case than it might be in the case of a painter. And that I think is why you see the question phrased the way it's phrased as an artist, because they had several amicus briefs in the last case about whether cake design was speech. They did not want to have a case about whether flower arranging was speech. They just wanted to say, okay, let's go with artistry and answer the question.
Right, but the plaintiffs do take the view that it doesn't matter whether the public perceives it that way or not.
That's right.
The act of forcing somebody to engage in that speech, even if they're the only person in the whole world who knows they've done it, is itself a violation of the First Amendment.
Did you understand?
Yeah, I guess I don't have that much more to add to what Paul said, but I guess I would say a couple of things. I mean, one way of looking at what Erin said is this is the camel's nose under the tent, and it's the easiest way to get under the tent. And once that happens, you are going to have these incredible problems. And I do think, looking at this broadly, both in terms of who is an artist, and I just reread Justice Thomas's masterpiece cake opinion, which was all about why cake bakers are artists. And I think once you say that, there are a lot of people who are artists. And I also think, looking at it from the societal perspective, I believe people who aren't getting married in the eyes of Jesus Christ are people I shouldn't serve, or I should only serve people who are Jewish and because I'm Jewish. I think the sort of fragmentation possibilities of what this means in terms of services and lots of signs on various businesses' doors about who they won't serve is just a really disturbing societal phenomenon that is apparently going to happen, and I think it is not going to be positive.
So is that because you think it's impossible to distinguish between the business that is speech and where the business owner is being made to speak versus just doesn't want to serve customers who are gay or Republican or blah?
No, I think you can draw the distinction between, I assume you can have fact finding about whether this person is willing to serve same-sex couples with respect to things other than wedding websites, and they probably are going to say they are. But I do think, as Paul said, what's so magical about weddings? Once it's weddings, I'm not sure why, a website for a law firm that serves LGBTQ people, and people think that promoting those relationships is inconsistent with their beliefs, so they don't want to provide services to a law firm that's going to sort of facilitate people entering
in the world of speech. I mean, for this case.
But the world of
for this case,
speech,
you gotta be in the
but
world
what
of
is the world of speech? I think florists say they are speech. Justice Thomas says
What
cake
about-
bakers are speech, dancers are speech, musicians are speech, painters are speech.
Lawyers are speech, right?
So there's a lot of speech out there, and once you sort of on the speech vector, you're covering lots of things, and on the I don't want to be associated with this vector, it's not just weddings.
No, don't get me wrong. I think like the other side, you gotta eat all of the, you can't say, oh, no, it would be different if it was, an interracial couple. Like, if you mean this, you mean this. And I think that, as a First Amendment purist, that's gotta be your position. We'll see how they deal with all that, but.
Well, the Trump Solicitor General, Mr. Francisco in the Masterpiece Cake Shop, he said, well, the government has a compelling interest in stamping out racial discrimination by private citizens. It's the gay people, they get to suffer, but nobody
Isn't
else.
there one small argument on the other side that you said lawyers or people in the wedding business, but it's true that most people in the wedding business want to do weddings and most lawyers want to serve. I guess I've had the experience of some of my colleagues when I remember going out to Masterpiece Cake Shop and talking to that guy there. And then I walked across the street and there were two other bakeries. And I said, and they'd say, Oh, sure, we would love to do, in other words, there was a dozen bakers nearby that would love to do a wedding cake. So it was a big matter of principle to say, whatever name, Jack Phillips didn't have to do it. But do you really think that there's all kinds of businesses around the country would say, now I'm really going to consider, I'm not going to serve people like him. I'm not going to serve people like him. I would have thought it would be the rare business person who says, I don't want to give.
Only lawyers in the second.
They're in Colorado, right, where the
Or
private
Washington.
states where a private citizen can bring a complaint against you because they bring a test case and say, you go into the florist and say, do this flower arrangement for me, right?
We all agree that the likely outcome is like some of the cases this morning. We think we know how who's going to prevail here. And the only thing I'm puzzled about is the thing you're talking about, whether this is a big deal, the beginning of a wedge or a camp that's going to make a major change in the law, or it's a symbolic thing to say, a business at some point, you don't have to violate your conscience to do it.
Yeah, but it's symbolic on one side, it's symbolic on the other side. If you're a discriminated against person, guess what? Seeing that sign in the window doesn't make you feel really good.
But I think the reality is you have to acknowledge it's symbolic on both sides. It's not, the flip side of your point about, she's not in the business yet is most of these disputes that have arisen are arising because someone wants to force the issue. It's not to your point that.
Yeah, no, although some people would say, the idea that in small town America, there could be a lot of peer pressure on businesses not to serve certain kinds of people. And it does depend on how broadly it can be applied. The First Amendment also includes a right of freedom of association. You have to let people in your Airbnb if you don't approve of them sleeping together. I mean, that becomes a much broader set of business, or into your pizza parlor, or, so where does this end? It's not clear.
I will also say, having just had a family wedding, the idea that the website was the speech of somebody other than the couple seems very bizarre to me, that anyone on earth would perceive it that way.
What am I going to use a custom website designer to say that?
So could we talk about, there's been another religion case kicking around in the news in the last couple of days, the yeshiva. Willy, could you talk a little bit about that?
Sure. This is a case brought, against Yeshiva University in New York State Court by a gay and lesbian student group that wants to be recognized, and Yeshiva is refusing to grant it the same recognition that it grants, the college Republicans or the quilting club, that on theological grounds, that recognizing the club would be inconsistent with the university's religious principles. And the university's main defense has been that the New York Public Accommodations Law doesn't actually apply to it because it is a religious institution like a synagogue or a church. And the New York State trial court has said, nope, the law does apply to you, and so you are required. But I think it has just said the case is going forward. They sought relief in the New York Intermediate Appellate Court, and then in the New York High Court. And New York has weird names for its courts, so I'm not going to use them. Then they came to Justice Sotomayor as the circuit justice. And after sitting on it for quite some time, long enough that they had to issue an administrative stay until a decision could come out, the court 5-4 denied relief on the ground that the university had not exhausted all of its options in the New York appellate courts. Now, one of the options it suggested was open to the university was to move to expedite. And if that's a form of relief, then that is very different than anything that I've seen on the shadow docket in a very long time. Expedited consideration by the New York Appellate Division might mean that you get a decision in 6 months. Damn it, I used the name of the court. Anyway, that was one reason, and they also said that perhaps there is another procedure whereby you could get review in the New York High Court, which seems more persuasive to me. And if you don't, they said, if you try these things and you don't get relief, come back. You're not barred from applying again for emergency. For justice dissent, Justice Alito, writing for himself, Justice Thomas, Justice Gorsuch, and Justice Barrett, said, number one, the four of us would vote to grant cert in this case. there's no jurisdictional obstacle. Number two, yeshiva should prevail on the merits because New York, this is a non-discrimination principle in the court's free exercise jurisprudence that I think has really come to the fore in the last couple of years. That the standard from the Santeria sacrifice case, Church of the Lukumi, is that a restriction can't be, it has to be non-discriminatory, right? And that the discrimination in the New York law between religious and other fraternal associations on the one hand and whatever yeshiva university is on the other is discriminatory because, for example, if you are the Benevolent Order of the Moose or the Order of the Scottish Hibernians or something, I'm getting those names wrong, but you get the basic idea. You are exempted from anti-discrimination law and not required to comply with it. Whereas if you are a religious university, you are being told that you must violate your religious precepts by recognizing this group. There's really only a paragraph on the merits in the Alito dissent. Doesn't say that much about it. It really focuses just on this line between the Hibernians and yeshiva. But it basically says if they come back, we're voting to grant cert, and there's no jurisdictional problem to hearing it. So it is possible that this will be added to the docket at some point this term. I think probably more likely it ticks along for a little bit longer. And I'll just add one kind of shadow dockety point. Justice Barrett early on in her tenure wrote a separate opinion in one of the shadow docket cases, the subtext of which was stop filing so many applications, I'm not going to vote to grant them all, but which pointed out that you got to show a likelihood of success to get emergency relief. Part of the likelihood of success ought to be, are you going to persuade us to grant cert? And I'm not going to vote to grant stays in cases that are not cert-worthy. This case, at a minimum, it has some jurisdictional questions about, is it too soon to come out of the New York state courts and go to the United States Supreme Court before there's been a recent appellate decision? But there's Justice Barrett joining the later dissent saying there are 4 votes to that there is a sufficient probability that 4 votes, there would be 4 votes there to grant cert.
So this vote the other night was a hiccup that's sort of procedural, but it doesn't really tell us anything in the end of how they will rule on this, does it?
I don't think so. I mean, Justice Kavanaugh, has certainly been a staunch friend of religious liberty claims. And
Say with the chief.
right, yeah, I mean, what they might think about the jurisdictional questions lurking in it, but there certainly are 5, if not 6 votes for the proposition that this type of discrimination is not permissible.
I'd be shocked if there were not 5 and probably 6 who think this is wrong. I suspect the vote the other day had much more to do with the kind of weird procedural posture and jurisdictional dynamics and things that are less related to the actual merits.
Yeah, and that's why actually I was surprised that there were 4 dissenters.
So these are the 2 cases before the court now, arguably. I was interested in sort of the broader question about religious liberty. I think we learned this morning sitting here, that we know the court doesn't like the administrative state, thinks it's out of control. They don't like the use of race in decision-making. And we know they do like religion claims. They're very interested in, they're very concerned about religious liberty. I was interested in if any of you could sort of say, if you had to look forward 3, 4, 5 years, what's going to happen in the area of religious liberty? Or what's going to come down the road next in this area?
This undue burden question, right? This TWA against Hardesty question about Title VII and an employer's obligation to accommodate religion and what the limits of that obligation are. And in this case from long ago, the court said hardship is the test, but there's an undue hardship if the employer has to bear more than a de minimis cost. Justice Marshall dissenting. And there have been many efforts to bring this issue back, especially because subsequent statutes, the ADA, for example, have an undue hardship standard that's defined as a much tougher standard for employers to meet. And there's actually a case, this Roth case that's pending, just got filed relatively recently that again raises this issue. I guess there were 3 dissents, 3 justices, current justices have dissented from denials of cert. So you think that possibly
This was a postal carrier who was a Christian and was told he always has to work on Sundays, right? They said,
Well,
no,
not always, but he wasn't accommodated in terms of not having to work on Sundays.
imagine that would register with someone.
I think it might register. And, you know, there was a dissent in the Third Circuit. And so you think there are many ingredients in the pot for that case to be granted. You know, there's a stare decisis argument, maybe on the other side, sort of.
Statutory stare decisis, yeah.
It's statutory, but the statute actually wasn't enacted at the time. Erin probably knows more about this than I do. The Hardesty was interpreting an EEOC guideline and the statute was enacted after the events at issue in that case. So there's a sort of an argument that there isn't really stare decisis. It's a little questionable to me, but I think another argument is Congress's enactment of these subsequent statutes that define undue hardship in a way that perhaps casts doubt, but we'll see.
I mean, the other thing too is, you know, because 303 creative is solely a free speech case, like there's gonna be the case in a couple of years that is clearly not speech. And then you have to squarely confront that issue as a free exercise issue, which I think the court's been kind of pushing that off ever since Fulton and the debate about whether to overrule Smith and exactly what we're doing with all of that. But, you know, I think the real question, you know, kind of in the wake of Fulton is the court, do they overrule Smith or just kind of keep narrowing it in such a manner that it doesn't really matter that much, because instead of having to think about it through the lens of laws, you know, I mean, what makes the Colorado case tough, the cases that have all arisen under this Colorado statute tough, is that it really kind of admits no exceptions. But like, if you take the Smith doctrine and the idea of, you know, Smith really only applies in a context where you have a law that truly applies with no exceptions, there's not a lot of laws out there that apply with no exceptions. So if you view exceptions as good enough to say if there's any exceptions, then religion is entitled to exceptions. I actually think you get rid of like a large chunk of what people think of as the Smith cases, and you have a pretty small universe left. But you have that universe left because of laws like Colorado law, so they're not going to be able to completely avoid that issue.
The religion cases, I mean, look, we're at a panel, on a panel at a conference. We like to talk about the divisive cases and all the defense and all this stuff. You know, religion, with some exceptions, has often been an area where the court has actually managed to get to broad, cross the aisle decisions, many of them unanimous, both on the free exercise side and also on the sort of, you know, where free exercise bleeds into free speech. Now, that's not always the case. Certainly, like the tuition case from last term, the court was divided along ideological lines. But Fulton is a good example, right, where the court did not take the step that many had predicted. It did not overrule Smith, and it ultimately wound up being unanimous as to the result, even though, you know, provoking some angry concurrences about rationale. And I think, you know, in the near future, there will be more agreement on religion issues broadly than there will be on some other areas. And the one kind of personnel point I would make about that is that, you know, Justice Breyer, I think, was very much of two minds about religion cases, because on the one hand, he was a pragmatist, he was a compromiser, he'd like to reach unanimous decisions. And yet there were certain cases where he thought too divisive. Carson was a good example of that. You know, I don't think Justice Jackson will just step right into the Justice Breyer role in exactly the same way. And there is a real opportunity for the court to forge common ground in religion cases.
Well, on the more divisive front, it does seem to me that building on last term, and there's at least a possibility we have interesting new cases coming up, both on the funding of religious education. You know, they distinguished Locke versus Davey in the case last year, but it's not exactly an easy line. That's the case about whether or not, when you get a scholarship from the government, you can use it to go to study to be a pastor. The court said, no, it's establishment clause violation, but given where they're headed, the establishment clause is like this.
It said it would, that the state doesn't have to allow it, even though it wouldn't be an establishment.
Yeah, it was fair enough, but you know, I think that given where the doctrine is headed about drawing distinctions between religion and other things that the state is willing to fund, that's an unstable decision. And then there's the whole issue of the football coach in the public schools and other public employees and teachers and classrooms and prayer, and where is that headed as well? I think that we are not going to see a lot of all 9-0 decisions in the area of religion.
I did all, but a lot more. The next panel was on guns and abortion, and
It's all relative.
We're all sweetness and light then. I do think the other area will be RFRA. There continue to be a whole bunch of RFRA claims directed at federal statutes. This Judge O'Connor decision about PrEP treatment for HIV, district court judge in Texas, that sort of seemed to broaden out what complicity could be in a pretty dramatic way. I think we just have to see where those go, but there clearly are going to be a whole bunch of those, and those tend to be divisive, especially when they claim employees or other third parties not getting government benefits.
Right, that's what I thought is the sort of controversial category. The category where some person who wants to exercise his religion, like the postal carrier who wants to go to church on Sunday, sounds like the kind of thing that all 9 of them would agree with. But a lot of them are the sort of Hobby Lobby type cases where the employer says, I don't want to pay for this or whatever because I have an objection to it. And this case from this latest Rita O'Connor case, I read, it just came out a week or 10 days ago. The businessman who won this says he's got 70 employees that work for him. He self-insures. He thinks none of them actually have these drugs that are expensive but help prevent HIV. But O'Connor said he suffers a dignitary harm because he has to have an insurance policy that could provide these drugs. And guess what? These people could go out and engage in sex and things that I find, as a matter, it takes the idea of being complicit very far down the road that he's provided. Because I think the same argument could be made about contraceptives. I had no idea, if I provide contraceptives to my women employees, who knows what they're going to do, and I don't want to be, it sort of opens the door, I think, to an area that is potentially controversial where it's the business owner says, I don't want to be in part of any benefit program if some of my employees are going to use the benefits in a way that I find troubling. That seems like it'd be a very broad argument. So that's one to keep an eye on. So could we talk about then, how about the other area of the Establishment Clause? I used to know, I thought, in general, what they thought was an Establishment Clause violation. It was never, entirely clear. But Justice O'Connor would use terms like the government, if it looks like an endorsement of religion or whatever. I know Justice Gorsuch, among others, they don't like the idea of endorsement. That doesn't do it. They sort of said what isn't an Establishment Clause violation, but I'm curious down the road, what would be an Establishment Clause? In other words, if a county in Southern Virginia says, we're going to put up a cross on the front of, and there's no coercion involved. Nobody has to, it's just a cross. And I'm not sure anymore what would actually be an Establishment Clause violation in today's court. Do you guys, would you know it when you see it?
I mean, coercion obviously is the core. That's what they distinguished in the Bremerton case.
So if the principal says everybody's got to come out, all you students come out and we're going to pray on the 50-yard line, that's a violation because he's pushing or coercing.
Kind of de facto pressure on the students that was in that record, but wasn't really finding or what the essence of the claim that was made, I guess, by the school districts, and they were able to get past that, despite the photographs that Justice Sotomayor put in her dissent of the whole team praying out there. So that's the core of it. Whether or not display of monuments is ever going to be sufficiently coercive, I don't know. What do you think, Erin?
I mean, I guess I think of that as like, there's a couple of different buckets of claims. So to sort of take everything else off the table and say, how do we decide like the cross cases? I mean, those are sort of, that's a little different to me. I mean, there still is a core Establishment Clause. I mean, in the Kennedy case, we were always agreeing that like, if in fact the coach had said, if you don't participate, like you don't get to play, I mean, of course that's a problem. Or if, anything that really makes it either is a condition of participation is a condition, or kind of you get penalized for not engaging in religion, whether that's in the school context or anything else, like, of course, that's a problem. So I mean, coercion is a thing and is a real problem. But I think what the court has said is we want, for an establishment clause violation in that context, there needs to be actual coercion, not kind of perceived coercion that in part because of the thing, but I mean, you can't eliminate perceived coercion. There's sort of nothing you can do. If you take this example, like the school district couldn't have made clearer to the world that it was opposed to him being out there praying, yet, the conception on the school district side was, it doesn't matter. There's nothing we can say or do because some people might think that we are endorsing it or feel coerced, even though we're doing everything humanly possible to distance ourselves from it. And I think
Football players, and they're overly eager.
Yeah, and I think what the court said is like, look, yes, it's not that we don't appreciate the reality that kids feel pressure to do what their teachers do or what their peers do or what their coaches do. We don't not acknowledge that exists, but we can't view that as the kind of coercion that counts with the Constitution because it's an impossible line to draw. So I do think that is where I think they've told us what they understand coercion to be. But I've always thought like the monuments case and stuff, they're just a little bit different creature because they're never really coercive in that sense, but I don't think that means the court thinks they're like 100% permissible no matter what, no matter the context. They just get a little bit, I think they're more.
How do they draw that line is always the draw.
Well, I think I think they've been trying in both contexts to bring it more toward a little bit of a historical tradition. And I mean, that's sort of what Justice Kagan was getting at in her way of thinking about it too, is when it comes to some of these things, like we are going to think about, look, if something's like consistent with the historical tradition we've had forever, like having, prayer to open legislative sessions, like we're not going to now suddenly say we've discovered 200 years after the fact that it's unconstitutional.
If I said 5 years, I asked the question sort of 5 years down the road. What about charter schools that are religious in the big cities? As you know, the last, 15, 20 years, most cities, even small towns, have gone to charter schools, and they have been publicly funded, but privately run schools. And the rule all around the country has been, they can't be religious. But the sense of the case from Maine is, I think there's going to be a move in some places to try to say, we've got this private school and we infuse our curriculum with religion. Something that's appealing that a lot of parents will find appealing. And I would think it would, once you get some sort of legal precedent on your side, a lot of the city of Chicago or Philadelphia or Los Angeles, you may well have a lot of publicly funded schools that offer a religious option. And I sort of assume what the court said is that would be fine by us. I mean, if you're going to allow these public schools, you can't discriminate and exclude the ones that are religious because they're religious.
If in all of these cases, right, the money has followed the private citizen, right? So in other words, this child or the family chooses a school, the program has the money follow the private choice rather than being directed by the government. So not all charter school programs are set up that way, right? So if you want a charter that goes to the Board of Ed and says, I want to open a charter school, give me the money, and then I'll wait for the students to come. That's
sort of the typical model, isn't it, for what a charter school is? It's established by a decision of the Board of Education.
Right, exactly. It is not like the Maine program where they don't have any school, so you get a check instead.
I'd be interested in Erin's view about whether or not that line could still be breached, because there's such a strong anti-discrimination theme in the court's recent free exercise jurisprudence. Anytime it feels like religion is not getting the full degree of respect of every other perspective, especially secular perspectives, they're very aggressive about it. And that does arguably carry the same thing. I mean,
Well, let's put an example on the table, so 300 parents go to the Board of Education and say, if you establish this school, we will send all our children there, and all the school wants is the money associated with our children.
Well, and where I think people arguing that all this is at a minimum, okay, and if not, you know, compelled to support the schools. But what I think you would say is the separation comes a little differently. It's less, you know, it's not at the front end of following the student, but no one's compelled to go to the charter school.
Right.
So it is still, you've still got the separation you need. And if, you know, if the money's going there, but nobody has to go to the school and every student has a choice to not go to the school, like, you know, I think there's members of the court that would think that makes sense.
The entire parochial school system in Chicago could be funded by the city, right?
Well, if the city's willing to fund, I mean, on equal terms that the city's willing to fund all of the private schools, I mean, non-parochial
Yeah.
private schools. So, I mean, but that's part of what the court said always is, if you don't want this, schools and communities, like, don't fund private schools. You don't have to. You never have to. But if you're getting into that business, like, then, you know, that's the decision you gotta make.
I think there's a second level of sort of legal problems as it goes with the public money that I think this has come up in Maine and it may come up is, yes, that's right, the strings attached. If you're the religious school and you're getting public funds, do you have to serve all kids? Or can you have, can you say no gay teachers or whatever? Can you discriminate in ways that the state finds? And I take it that's not resolved or not clear yet, right?
No religious school in Maine, I think, has wanted to participate in the program.
If the strings come with it.
Right.
Okay.
Which the Maine government says they do.
And they haven't brought a challenge to say, cut the strings.
Right, and that was the standing issue that was lurking in Carson, but the court didn't really give much attention.
One other small question I've been unclear about. Does it matter whether the court does overturn Smith or not? This is, we were talking this morning about different Chevron or whatever that just sort of sit there dead in the water. Is Smith, is it important whether the court takes up and overturns Smith, or they seem to be deciding these religious cases without actually confronting
Aaron's
Smith?
point was important. If Fulton basically, if there are an infinitesimal number of statutes that don't have another exception, it sort of doesn't matter.
That's the point, yeah. I mean,
If that is the law, that as long as you have an exception, you gotta
it's
have.
not a generally applicable law, therefore you have to create a religious exemption, and they really strained to find the
I
exception.
was gonna say, I'm glad you guys understood what Fulton decided. I think I know who won. It was 9-0. The Catholic diocese won, the city lost, but what they decided, it just seemed very,
I've never quite I mean, maybe this is just me reading things into things or being a chief clerk, but like, I've never quite understood why everybody thought Fulton was such an exceptionally narrow decision. I'm not sure it completely is, because I've always thought it actually really does stand largely for the proposition that if you have exceptions, and if that's the law, then I think Smith matters in a vanishingly small number of cases. I mean, it will matter in cases that are absolute public accommodations laws, and that's why you get some states that are passing absolute laws with no exceptions to really push that. But most, I mean, but in a sense, if you think about that, you can think about that as a good thing, which is to say, I mean, there's a political check on all of this, which is, look, like, you got to be willing to not give anybody exceptions. All the people that are going to come in and say, you know what, like, I understand you want a contraceptive mandate for the Little Sisters of the Poor, but we don't want one for our small businesses, or we want to grandfather it in for the big companies. Like, you got to say no to everybody in the political process, which in reality, is rare that legislatures are willing to do that.
so your understanding of the law, and you know it and I don't, is that the Smith principle still survives intact, that
I mean, they haven't overruled Smith.
No, it's like Chevron in this sense.
you have to be neutral, because I thought somewhere down the road, Scalia's view or insight will come back, because once you open the door to religious exceptions, you start to get all kinds of, I mean, that was his complaint, was that, you get all these, the fellows who chew peyote and then lose their job because they're using drugs. I mean, how are you supposed to decide that? And his view was to sort of throw up her hand and say, we shouldn't decide all this. If it's a neutral law and it's not targeted religion, we're not going to go down the road of exceptions. I sort of thought this court is much more sympathetic to religious claims, religious exemptions, and they're going to go down that road for a while until they get a few crazy examples that.
And you wonder how much RFRA had to do with that, right? The court, they sort of have to do it anyway now for federal law. So, you know, you sort of wonder whether that sort of changed the environment a little bit.
People certainly spun around on RFRA, right? But Justice Barrett's concurrence in Fulton was sort of like, well, okay, if not this, then what? Right, so like you could say they might go down the road a ways, but I think her point was we don't know where that road bends and certainly not where it's going.
I'm not clear on our time, but do we have 5 or 10 minutes to take questions if anybody? Any questions? Michael?
Yeah, this is sort of a cosmic question, but I'd be interested.
We're talking about religion.
Right place.
People view whether under RFRA or First Amendment jurisprudence of the status of people who have conscience issues, but don't link it to a religion and don't use the R word. I mean, we have the precedent of conscientious objectors, I think, some of whom said, I'm not really a traditional theist, but I have a deep opposition to fighting in Vietnam. Does the current law equally hospitable to people who would say, I don't believe in God, but I do believe that, contraception is bad, or abortion is bad, or registering for the standby draft is bad. Is there a sort of equal
Sincere
footing,
moral belief.
equal footing for non-religious conscience claims?
I don't think so. No, I mean, it says the free exercise of religion, and RFRA is about freedom of religion. And so I think you have to articulate it as a religious in some broad sense. But if you actually go out of your way to say, I don't believe in any God, it's just my personal moral philosophy, I think that loses. I could be wrong, but I think that loses.
I mean, it got teed up a little bit in the context of the last contraceptive mandate rule because there was protection extended on moral, not religious grounds, and there was pushback on that. But I actually think it's a little hard and feels like it feels like exactly what you want the religious clauses to kind of protect against is the idea of like, okay, if my faith is not faith, like that shouldn't mean I don't sort of get the same protection. But the law is pretty underdeveloped on it, frankly. I mean, I'm sure there's probably some older cases, but it's not something people.
The Stevens concurrence in the city of Bernie said that RFRA 1 was unconstitutional because under the Establishment Clause, and I think part of it was because it did not provide accommodation of non-religious people.
And the ACA case was really about the broad exception power as opposed to saying these things.
Yeah.
Thanks. Any other religion questions? Yes.
I understand that there are certain philosophies that do give a broad reading of absolutism to exceptions. But doesn't that start to get dangerous because we'll take Christianity as the dominant religion in our country, for example. At what point is it okay to tie something to one's religious faith? There's a dark history there that KKK did have.
I mean, I guess I would say like one important component of all of this, and I don't mean this as a solution or anything so much as just like really an important thing to think about in all of this context is sincerity. And I do wonder if, the more the courts go in the direction of saying like, as long as there's exceptions, religion always gets exceptions, if we'll start to see lower courts, the way that, or kind of through litigation, that pushback happens is taking harder looks at sincerity. That in itself is tricky because there's very strong law about like not second guessing sincerity of religious beliefs. But that is tricky, and that is a legitimate concern that has to be part of the whole kind of doctrinal evolution.
I guess my own pushback to that is it would just be very difficult to argue that the KKK was not.
I mean, that's.
There's no question there were religions in this country that had beliefs in favor of segregation and inferiority of some races, and they were sincere. They tried to make arguments, and they may come back with some of these issues like the post 303 creative and
And so RIFRA says apply the strict scrutiny in those cases, right? And the Francisco brief you alluded to says, okay, then there's no issue for race discrimination, but leaves open everything else.
Any others? Yes.
Following up on that, do you think the abortion context might be a place where that comes up with this synagogue in, Florida? I mean, there's been some conversations about the idea that maybe the representation that Jewish religion, when a rabbi, tells a woman that under Jewish law she should get an abortion, that there were challenges to the sincerity of that. So do you anticipate having kind of the sincerity issue come up in that context?
The one thing that, I think the law could not be clearer on is you cannot second guess sincerity on the basis of sort of people in your faith disagree. And so we're going to decide who knows what really is the Jewish faith. Now, the tricky thing is there's a very fine line. If you're look, 99.99999% of people in this religion say that's not what our faith says, and you seem to be the only one in the world, boy, that seems like evidence that ought to support sincerity. But I do think when it really seems like you're coming to the court and saying, we want you to referee a dispute, we're going to bring in kind of our, rabbis, and they'll bring in theirs, and we'll decide who's got the best of it. Courts, that we know they shouldn't
Do
do.
you think that under where the law is going, assuming sincerity, if a religion that affirmatively believes people have access to abortion services, that's the kind of thing for which an exemption could be claimed?
I think if the court's still going to have I guess it all depends if you're coming up under a RIFRA type test with strict scrutiny,
Well,
like,
It's a federal law, but.
if where it goes constitutionally is a
This
strict
comes out of
scrutiny
Florida?
test, if it's a
We'll
strict.
wait for the
scrutiny
11th
test.
Circuit to weigh in on that. Think about it. Catherine, I think this is the last.
So I was really struck by a couple lines from Justice Alito's dissent in the Yeshiva case. He says twice that the First Amendment prohibits a state from enforcing its own preferred interpretation of Holy Scripture, and that's what New York is doing in this case. So I'm just interested in any thoughts you all have on that way of characterizing, a public accommodations type law. Is it rhetorical flourish? Is there a suggestion that these kinds of laws violate the Establishment Clause? I mean, he's not talking specifically about the Establishment Clause in those lines, but I thought that way of characterizing these laws was really striking.
On this point that Erin's been talking about, right? Because look, I haven't read any of the underlying papers, but as he characterizes the claim brought by the student group, it is that they disagree with the university's interpretation of halacha, and that therefore the university has no well-grounded and sincere religious objection, and therefore they should follow the same law as everybody else.
But he's saying that New York itself, it has interpreted Holy Scripture in a way.
I thought it was talking about the plaintiff's interpretation of Holy Scripture, and that
He does,
I mean, I think what
he does
he's
turn it
saying-
into this phraseology.
But I think where he's getting
Read the
there is
first line of the-
for
of
them
the
to
sentence.
win, the courts have to accept the proposition that the students, rather than the school, are right about whether the student group would be consistent with I think that's the chain that he's following to get there, that, you end up having the New York courts essentially saying the students have the better of the argument about the Jewish faith.
In the paragraph where he talks about what the student group's claim is, it begins with a quote that says vigorously disagreeing with their interpretation of Jewish law. So I think that's what he's referring back to.
So on Yeshiva, stay tuned. All right. Well, thank you. I think we've used up our hour.